Good afternoon. Good afternoon. My name is Ward Stone. I am counselor of the Inn for this year for 15-16. I'd like to thank you all for turning out for our first pupillage program of the year, which has been put on together by Ben K. Done a wonderful job. Been working on it a long time, and I've been looking forward to it, as I know you have. I'd like to recognize some special attendees this afternoon. Some are here, some are expected. Judge Hall is not here yet, but Judge Randall Hall, U.S. District Court, will be here today, we think. Judge Bowen has indicated he will drop by, and we hope to see him. Judge Barrett is here, and we'd like to thank Judge Barrett for all of her help in putting this together and allowing us use of the courtroom here today. It's a wonderful facility. Those of you who haven't had a chance to see it, I hope you'll tour around and appreciate all the technology. Those of us from the Middle District especially appreciate the technology, whereas we have microphones and megaphones and that's about it. Judge Davis is here today. We thank you for coming up. Brian Epps, our U.S. Magistrate Judge, is here today. Thank you for attending. Judge Laney, who is our president this year, was unable to attend today. And the rumor is that Judge Walker is coming. Have you seen him today? Okay. Well, the rumor is he may attend. I hope we get to see him. I understand he's recuperating well and doing much better. I'd like to point out our next program will be on November 5th in tandem with the State Bar retreat at Lake Oconee at the Ritz-Carlton. We'll have a program. We're co-sponsoring one of the programs on November the 5th, and we are attempting to arrange a luncheon that day after the program adjourns. The State Bar program will adjourn at 11:30, and the Inn may sponsor a luncheon immediately following that. We're putting together the next pupillage program following that at Georgia State, which we hope will be in January or February. Georgia State has been moving. For those of you who don't know, the law school is relocating to 55 Park Place in downtown Atlanta, and they are getting their facilities set up and their IT systems together, waiting for our use, and we look forward to that. The annual meeting has been rescheduled for June the 11th in Macon at Idle Hour Club, and we hope that you'll hear a lot more about that as the year goes on, but we hope you'll all make arrangements to try to attend. And thank you. Corrected. January 26th is the session at Georgia State. We hope as many of you as possible can attend that. So without further ado, Mr. Kay.
Thank you, Ward, and welcome everyone to Augusta. And Chairman of the programs, Kathy Horn, and I would like to especially thank Dave Berry and Grant Stein and the IT committee for their great work in providing the IT today for this program. Now, we are fortunate indeed today to have with us David Zacks, and David's going to talk to us about whether or not and when we should consider mediation in bankruptcy cases. David is a veteran trial lawyer. He has been one for more than 45 years. He's now transitioning to full-time mediation through Henning Mediation and Arbitration. A successful litigator, David took an early lead in mediation in the 1990s. In 2014, he founded Zacks Resolution, LLC, and that helped him shift his career focus to mediation. David has a deep expertise in healthcare, personal injury, not-for-profit organizations, and complex business issues. He's received numerous top honors and awards, notably the inclusion in Best Lawyers of America for Alternative Dispute Resolution, healthcare law, mediation, and personal injury litigation, inclusion in Best Lawyers in America for Atlanta Lawyers of the Atlanta Lawyer of the Year for mediation, and he's a founding member of the Georgia Academy of Mediators and Arbitrators. Now, not only is David an accomplished professional, but he's a tireless and dedicated public servant. His volunteer accomplishments include National Chair of the American Cancer Society, Chair of the Wake Forest School of Business Board of Visitors, a member of the Wake Forest Baptist Medical Center Board of Visitors, and he's the past president and founder of the Legal Clinic for the Homeless in Atlanta. David is a past trustee of Leadership Georgia, and he's the recipient of the Atlanta Bar's Palmer Ansley Leadership Award. David served as a captain with the Judge Advocate General, and upon receiving his honorable discharge from the Army while he was stationed out here at Fort Gordon, he joined and became a partner in the Augusta law firm that's now known as Hull Barrett. He later was a founder of the Augusta firm of Knox and Zacks, which subsequently merged with Kilpatrick Townsend. David is married to the former Barbara Jones of Augusta, and they make their home in Atlanta. Welcome, David Zacks.
Thank you. The good thing about being here is I really feel like I'm home. I look out at this audience and I see Judge Brian Epps, who made me look good in my firm. I see Judge Susan Barrett, who worked for us and made me look good in our firm. I see Ben Kay, who, when I got out of the Army, I made him look good because I told him, you can have this Army uniform. He was in the National Guard or something, and we were about the same size. I hadn't seen my uniform since, so this is not like a strange audience to me, and we're going to talk just as if we're sitting around a living room discussing things. I don't want you to think, my gosh, I'm going to be here 45 minutes, you know, having somebody lecture to me. I hope you won't feel that way at the end of this. I've tried to think, after Ben asked me would I do this, about some stories that happened to me here in Augusta, not just things that happened to me in my career. And all these are true. I had a case in the Superior Court of Richmond County in which we were the plaintiff, and I was offered $1,200,000 to settle it. I thought, you know, that offer's not going to go away. Let me see what the jury is going to look like, and if I think I got a good jury, it was close, what we thought. If I got a good jury, I might just try this thing. And if I feel like this is really not a good plaintiff's jury, I might take the offer. On the jury, I recognized a woman whose husband was a colleague of mine in the Augusta bar. And honestly, I thought I got a ringer here. I knew her. I knew her from the Augusta Country Club. I was just elated. I tried that case for 3 days, and we got a verdict for $600,000. So I left $600,000 on the table. I met her as she was going to her car. She was the foreperson of the jury. And I said, can you just tell me what was your thought process of reaching the verdict? She said, I'm so glad you asked, David. I knew you'd be thrilled, because Hugh always told me that lawyers always ask for a lot more than they ever expect, and I figured, you know, if we give you about half of it, you're going to just be thrilled. I swear to you, I've never had a lawyer or anyone related to a lawyer on a jury from me since that time, if I'm a plaintiff in any matter. You live and you learn. The worst case I ever tried professionally, I got one of my largest verdicts. It was here in Richmond County. It was in the Superior Court. I was a plaintiff for a woman who was the choir director of a church. And a Japanese citizen who was not understanding the way our traffic works ran right through a red light, hit this woman, and her throat hit the steering wheel, cracked her larynx. Her career was over. She had been to Juilliard School of Music, everything. It was finished. During the trial, I thought I had one small element of damages I also wanted to show. She had had 15 stitches on her throat, so I wanted to also describe the physical disability, not just the main disability that she had a raspy voice for the rest of her life. So I asked my partner, Wick Knox, I said, Wick, I want you to do one thing for me in this trial. When she puts her head back. I've gone over to this Frank Christian Studios and borrowed a photography light. And all you got to do when I say, I want you to show the jury your scar, she's going to put her head back, and all you got to do is stand up there and cut the light on for me. He said, I got it. So Wick sitting up there, I said to the lady, I'd like you to show the jury your scar. She goes like that. Wick cuts the light on, and the bulb explodes. The judge screams, the jury screams, the poor plaintiff's about to die. Wick, I just don't want him to laugh. Seriously, if you knew him, you'd know what I meant. I'm just, please don't do anything like that. And fortunately, he held it together. And, we apologized to everybody, said we had no idea this would happen. It has no bearing on anything. And then I said, give me the next deposition or something. I get her down, and I'm bringing up some doctor. They hand me the wrong deposition, and I put it back. I said, no, this isn't the right one. Give me the right one. I think it's at the office, David. So anyway, I just winged the whole deposition. We finished the case, and I got an enormous verdict for this lady, enormous. And almost everything I could think of went wrong in that trial. I asked the foreperson of the jury, kind of a fluke, who was also a female, could you explain to me how the jury reached its verdict? She looked at me and she said, we got back there in that room, and I told that whole jury one thing to start, and they should never forget it. My son's got curly hair, and that little fella next to you, Mr. Chadwick's got curly hair, and you got a little bit of curly hair. I knew y'all were honest, and anything you said was the truth. All right? So I think what you can learn from some of these, I wish I could tell you, I was making them up. This happens. This happened here. I can tell you ones every other places in Georgia anyway. But what it shows you is trying a lawsuit is a crapshoot. And the older I got and the more cases I took to trial, the more I really saw that. Sometimes lawyers have no choice. We had the Casey Lockhart case, and I remember my opposing counsel was somebody who became a really good friend of mine. He's now a federal judge in Macon, Ashley Royal. At the time, he was on the other side. All this is public because we tried him. And in this case, we sued Little Oak Mulgee Power and Electric Company near Dublin because they had been notified that a house trailer was being moved from point A to B and to cut the power off. While this thing's got to get under the power line, and the moving company has a kid that gets on the top and literally lifts the power line so the trailer can get under there when the truck moves. Well, the power was on. This young man, Casey Lockhart, literally was electric shock on his hands. It throws him off. He recovered everywhere but for his hands were paralyzed, and he refused to have the doctors amputate his hands, even though they explained to him 100 times how prosthetic devices could work. He had no feeling in his hands. He couldn't move them, but he wouldn't allow him to do that. There was a claims adjuster who came here. I think he was from Kansas, and he met in our office. Ashley was here. We're meeting with him, and he comes in, and first thing he said to everybody, we're in a conference room waiting on him, he said, "Man, I hate the South." First words out of his mouth, I never forget. He said, "All of you talk funny. It's hot. I've never seen traffic like you got in Atlanta. Let's just try and get this thing done and get out of here." That was like opening, "How are you?" So he then said, "I just want you to know I've done my homework, and the largest verdict in Dublin," that's where this case was filed, is it Loudoun County? I can't remember, but in Dublin, Georgia. He said, largest verdict's been something like $25,000. So I feel real sorry for this guy, but we'll go 90. Well, we're thinking this is $1 million case. And we said, you're not even where we can negotiate. And never had any problem with Judge Royal. It was almost like we were a team, but he had to try the case. He knew that. The insurance company wouldn't put up any money. We tried the case down there, and I still can remember in the closing argument, when I asked the question, what do you miss most about the use of your hands? And he said, I never went to school, but I went fishing. And I had my dog by my side. And I loved to pat his head because he liked it so much, but I never knew how much I liked it. But I can't feel that anymore. And we rested. And we got $1 million. And sometimes you just have to try a case. There's no choice. But in other times, I find lawyers think about, do I try a case or not, all about the money. It doesn't matter if you're a plaintiff or a defendant. But I ask all of you to also consider, what about the time? Did any of you know Lyman Dillon, who was with Hansel Post? It became Jones Day. I knew Lyman. We were in a tent together, Ben, at Fort Bragg. He went to Davidson and then to Duke and was a lawyer. And he called me. I'm down here in Augusta. And he said, David, I want you to be local counsel for me. That means when you're an Atlanta lawyer that you just come down for things and bill by the hour, and the guy down here in Augusta does a lot of the work. That's what was going on in this case. And so I said, Lyman, I'd be thrilled to do it. It dealt with some real estate appraisal issue. Hull Tower was on the other side. I remember Pat Rice, one of my closest friends, he was on the other side. And anyway, we're getting ready for the deposition of the real estate appraiser. No one had come in our office yet but our real estate appraiser, and we hear our secretary yell, and Wick and I run out the reception area. He had dropped dead of a heart attack. Of course, we were shocked. Certainly that's what made me learn CPR training, which I'd suggest everybody do. But after that, jump forward, we get another witness, he gets his deposition, and now we're trying the case. Now, Lyman had come down and, of course, saw this tragedy and goes back to Atlanta. Nothing happened. We're now striking the jury, Pat Rice and myself. Pat's on one side, I'm on the other. And we hear something like snoring. Judge Fleming was the judge, and a juror falls out of the jury box dead. Same case. Of course, everybody wants a mistrial. There was no issue. Nobody's going to try that case that day. And Lyman Dillon looked at me and said, David, you know how you're local counsel? Well, you're the counsel. You're local. You're prime, because I'm never coming back. There's not going to be a 3 strikes and you're out with me. And what that shows you, though, is that case took some years to try. So when you're thinking about resolution and getting something accomplished, it may not be the smartest way to go. Now, this is in regular civil litigation, not bankruptcy yet. In all those cases, when we try them, the objective is to win. But when you mediate, your objective is always, how can we reach a fair resolution? That's very different. As we go through and kind of move from what happens in bankruptcy issues, I'm going to be mentioning to you several cases, and I don't want you to try and write things down, but enjoy this. I can share this with you when it's over. I'm really going to be focused on 3 cases, and I'll give you those citations now, and I'll repeat them again when we're done, so you don't need to think about taking notes or any of that stuff if you cared to. I think the best review on the uses of mediation in Chapter 11 cases is by Professor Ralph Peoples in an ABI law journal. And then there's an N. Ray Smith case, which is terrific, a 2015 case in 524 Bankruptcy 689. It's a Southern District of Texas bankruptcy court case. And the last one is a Reynolds, A.T. Reynolds and Sons at 424 Bankruptcy 76. It's a Southern District of New York case this year. So what do you have to consider if you're a bankruptcy lawyer and the issue comes up? Should I try and mediate some or all of this? I hate these true stories because I'm going to try and teach you something before we're done. But a few months ago, I get a call, a bunch of lawyers on the line. David, how much bankruptcy have you done in the past? I said, I've never done any in my career, but thank you for considering me for some mediation issue. And I hang up, think that's good, but That's just not something I've done. Called back, a bunch of others the next day, tell me what's basically your background. I said, well, I've done a lot in the healthcare industry, business disputes and personal injury. Those are really my sweet spots. And I said, but I just finished a patent mediation matter. I can read, but I don't know anything about bankruptcy. We hang up. And the next day, this group of lawyers said, we'd like to hire you in a Chapter 11 bankruptcy proceeding. I said, well, I've given you the disclaimer, and it could be a total waste of time and money, but I'm happy to learn, and if we think we can go down that road together, let's try it. And we did. What I learned as we did it, this was a number of lawyers, it was a large case, but the trial lawyers had hired bankruptcy lawyer specialists. Each side had one. So the first thing I did, I had the team of lawyers and I would separate them. I don't mean at a mediation. I was working with them some month before the mediation. Privately, I'd tell the lawyer, I said, okay, you're a bankruptcy specialist. You got this trial lawyer over here. Do I have your word that I'm going to consider you an officer of the court when you and I are together? If I ask you what's the rule, I expect not your being an advocate, but tell me the truth and don't sugarcoat it anyway. And I'm going to expect the same thing of the other bankruptcy expert, or I'm recusing myself. I had that promise. And that's how we started. And they were a terrific help to me. They'd tell me something from time to time. I'd look it up to just see whether or not they were straight up, and they were. I felt the diplomatic stuff that we did beforehand, the caucusing privately, helped a tremendous amount because a lot of groundwork had been done before we ever went to the, quote, day of mediation. So I do think it's important, but remember, in mediation for a bankruptcy issue, it's not like other mediations. We didn't have a deal. We had a deal subject to the approval of a bankruptcy court. So it's a very different animal, and we'll get more into that in a minute. I think I'm not pandering to the judge here because I'm not a bankruptcy lawyer, so I don't plan to be here. I wouldn't do a bankruptcy case if somebody called me on it. But you've got the greatest bankruptcy bar in Georgia. I mean, my former law partner is one of my best friends, Ray Mullins, if you know him in Atlanta. He is terrific. You got Judge Dallas, you got Judge Barrett. My fraternity brother, Pete Bowie's a bankruptcy judge in San Diego. I mean, there are just so many good ones that this particular bar is fortunate. But I think any of these judges would tell you that some of the main differences that you and your specialty face that I did not when I was considering whether to mediate a case or not is you have a finite pot of money. It's not normal litigation. In many cases, the parties are hung up in the midst of a dissolution proceeding. We don't have that in other cases. And there are a lot of forces at play other than just rational economics. In bankruptcy, you got an umbrella for all a debtor's economic relations, not just the you sue me for a slip and fall or medical malpractice event or some single transaction. And you deal with the whole universe of this debtor's economic relations, and they will get paid out of whatever non-exempt assets are left in accordance with the statutory priority Congress established many years ago. So that is a very different standard than when people say they're going to go mediate a case. Again, not being a bankruptcy lawyer, I think there's some cases more attuned and situated to mediation in bankruptcy than others. For instance, a Chapter 11, to me, there you do have a pot of money that's available. It seems that might be a little easier than a Chapter 7, a discharge case, or a wage earner case in a Chapter 13. Although I can see in every one of these situations, you may have a situation where you can really assist the court in expediting matters with trying to carve out some of these places and speed it up and expedite it before the judge rules. The importance, as I mentioned, of this case of Cody v. Smith, and I can't take any credit for reading it. This is a very recent case. When Ben Kay called me, he said, Judge Barrett found this case. I suggest you read it. I thought, man, I promise you I'll read it. That's kind of how I found the case, so I can take no credit for it. And I'm not going to go through any of the facts because I don't want to waste time there. I do want to give you some of these conclusions that are so important. In this particular case, the lawyers for both sides decided on a particular bankruptcy court judge who had retired to be the mediator. And he was a fellow in the American College of Bankruptcy. He worked together to coach moot court teams. He served on the bench with the particular judge who had this case during the same period of time. Everybody in the community knew they were friends and colleagues. And when the judge heard, this is after the fact, that this particular person had been the mediator, she wouldn't approve it. She said, this is the kind of cronyism that the whole Bankruptcy Act is trying to prevent. And what it tells me loud and clear is if you have a bankruptcy matter you think is ripe for mediation, I see no downside in seeking the court's approval of the process and the mediator before you engage their services and conduct the mediation. It's almost like team building versus you could be at different ends and maybe even get all your work disapproved, and that doesn't help anybody in the process. This went further, in which the sitting bankruptcy judge who said, I'm not going to allow this, the case came out with 10 factors that this court said they would consider in deciding whether or not the parties should mediate when estate funds are at issue. First, the subject matter of the dispute. Is it one that looks like mediation would be appropriate? Second, the amount of discovery completed. Example, you don't want to go through all your depositions and discovery and then mediate. Conversely, you don't want to mediate without having any discovery and no one even knows what they're talking about. So you have to find that balance of when do you know enough to be effective. 3, the amount of time the attorneys have spent discussing settlement with their clients and whether the lines of communication with the clients have been open. The lawyers shouldn't get together and say, let's try and mediate this and shortcut what's in front of us, and the clients don't even know what the process is. How do we know if they want to do this? Have you sought their input? 4, the amount of time the attorneys have spent discussing settlement with opposing counsel. You don't want to go do it without both of you being cheerleaders for it. And instead of having a judge here, one wants it and one doesn't, that's not a very effective way to start a mediation process. This judge said she would want to know the actual courtroom experience of the attorneys in adducing testimony and introducing exhibits, because you don't want to mediate just because, as an example, a young lawyer is afraid to try a case. And today, fewer and fewer cases are tried. 6, whether the attorneys have explained the mediation process to their clients and reviewed with them the cost of mediation versus the cost of scheduling a hearing or trying the case. The name, qualifications, and the fee proposed by the mediator. If it's for me, I'll call them back. 8, the estimated cost for each client of the mediation. 9, the percentage of the estimated cost to the estate. And this one's really important. 10, whether any of the parties are opposed to mediation because they want their day in court. And in this case, it had a true example of a president of a small bank in a rural community who had been accused of forging a debtor's signature on a renewal note. He may well want to go forward with a trial to preserve his reputation in the community rather than get this matter resolved in a confidential mediation that can never be disclosed to the public. That would be an example of where mediation would never be appropriate. In sum, the undersigned judge, this is a quote, does not belong to the school of mediation romantics who believe that mediation best resolves all disputes and leaves all the parties walking away with warm and fuzzy feelings toward one another. So I think if you can keep some of those points in mind, to me the most important one is get prior court approval. I just see no downside to that. And if you do decide to mediate, pay attention to the warning signs in the second cite that I'd given you in the Reynolds case. This one was pretty shocking. This is where lawyers for Wells Fargo and the client were sanctioned by a court. In this case, it was court-ordered mediation, and I think that's very important. And in it, Wells Fargo, their counsel came to the mediation, but they did everything wrong. Listen to this. Despite the freedom of any party to adopt a no-settlement position, sanctions may result when a party refuses to engage in the process. Here, Wells Fargo failed to send representatives with full settlement authority to the mediation. Now, the real operative word there is, what does full settlement authority mean? I don't know. The case doesn't describe it. I spend a lot of time before I start a mediation trying to make sure I have no issues with the parties about authority. If it's a plaintiff, I'll look at a plaintiff and say, sir or ma'am, are you prepared to say accept or reject whatever's offered to you today? It might be a dime or $10 million, but are you prepared to do that? And I literally am checking, are you under any medication? How nervous are you? Not just can they do it, have they talked it over with their lawyer? And then I'll get the defense side, which is normally the bigger problem, and I'll see, say, a claims adjuster, and I say, do you have what you consider adequate authority to start this process? And I get assurances, yes, from everybody. And if I don't, sometimes I don't even start the process. I mean, I just see no reason to do that to the other side. In this case, Wells Fargo did not have that authority when they started. They refused to engage in a risk analysis. Most good mediators will do a lot of validity testing, will bring the lawyer privately in and say, if you were to try that case 9 out of 10 times, how many times do you think you'd prevail? Let's talk about a motion for summary judgment. How worried are you about that being granted by the court? I know they're usually not being granted, but did you take a look at case so-and-so that I read in the brief before coming here today? I don't just go in and swap numbers, and I don't think most good mediators do that. Here, the Wells Fargo attorneys just stonewalled it. In other words, they came in, no settlement authority, did not engage in the process at all. And the court also noted that presence by telephone is insufficient. Toward the end, they said, well, we'll just get somebody on the phone. And so in this case, again, court-ordered mediation, the conclusion was attending a mediation session without authority to settle is tantamount to not attending. The Reynolds case illustrates that parties compelled to mediate by the court cannot attempt to limit or obstruct the mediation process simply because they believe the process will be a waste of time for them personally. So it's just something to remember as a cautionary note if you go forward with this mediation process. I found 2 wonderful quotes as we're going to move into, well, if you do mediate, what do you consider, by Chief Justice Warren Burger. One, he said, is the notion that most people want black-robed judges, well-dressed lawyers, fine-paneled courtrooms as a setting to resolve their disputes may not be correct. People with problems, like people with pain, want relief, and they want it quickly and inexpensively as possible. He also said where the parking meters now stand were hitching posts for horses. The horses and buggies are gone, even the trolley cars are gone, and men like Henry Ford, Louis Chevrolet, the Wright brothers have altered our lives dramatically. Yet we see fundamentally the methods for settling disputes remain essentially what they were in that day. Perhaps what we need now are some imaginative Wright brothers of the law to invent Henry Fords of the law to perfect new machinery for resolving disputes. Now, I'm not telling you that mediation is that end all, but I do think that good mediators are very different than possibly, say, good arbitrators, or even maybe judges in some cases. Good mediators should think differently. In mediation, the neutral employs mostly right brain or creative mental processes. They use intuition, holistic, symbolic, emotional approaches because the role of the mediator involves instinctive reactions, interpersonal relation skills, and the ability to perceive subtle psychological and behavioral indicators in addition to logic and rational thinking. And sometimes I think it's much more difficult than when I have my role as an arbitrator. There I listen, I rule, and I write an opinion for how it came out. While I think most mediators can effectively perform the arbitrator's function, I'm not sure the reverse is necessarily true. But let's say that you've selected your mediator and you think as a bankruptcy judge, after hearing these few cautionary tales, that you have a case that is ripe for mediation. How many of you have participated in a mediation? Okay, so about 2/3, which means I have no idea where to go with this. But I want to go through just a few sticky issues with you. And when I say sticky, these are things that come up pretty regularly with me. And we're going to talk just for a moment about how you might handle them. You're in the middle of the mediation. I'm your mediator. And I come into the plaintiff. I say, Ben, I hate to tell you this. I know where we are in the negotiating process. We've traded numbers about 3 times. We've been here for 4.5 hours. But I'm certain, and the other side wanted me to communicate to you, they do not have adequate authority. And they're just hearing things they didn't expect to hear. What do you want me to do? What does Ben K say? Continue the mediation? Ben says he'd stop it. The problem when you're a plaintiff is this is almost like your day in court. They're built up to it, but clearly, I'll stop it to me is one of the first things you should consider. I think it's much easier to reach that conclusion if you hear the lack of authority issue the earlier you are in the process than as it goes down the road. It's really hard if you hear that after you've been in there, say, like 2 days. But if you hear it at the beginning, it's easier to reach the conclusion Ben did. So certainly that's one thing you would want to put down as a lawyer if you hear, I just don't have the authority, I'm sorry. What would be something else you could consider? We heard continue, but how would you continue? Here they tell you, I don't have the money to pay you. And you say you would continue, and you're on a good track.
I'd ask the mediator whether or not they get the authority, expand the authority, and if so, how much time they do.
Let me tell you what's a good tip that I've seen happen. When plaintiffs come in and they have a good PowerPoint presentation, and the mediator is there, use the mediator to say, I want to make that claims guy who's not here with enough authority be my good messenger to his company. He should be embarrassed, and I'm not here to embarrass him. I'm here to get a fair resolution. But you need to tell him, I want him to be a good messenger. And why don't we, instead of we're broken up in these 2 different rooms, let's all get together in one joint session. I want him to review again the PowerPoints I showed in my opening when we're all together at the very opening session. And I want to talk about them so that he can be a messenger for me in taking the right information back to the company in hopes that we can have a conference call and get the amount of authority to get this done. There could be a third approach to continue. You're not going to get money, but what about getting all the information you can from the attending party other than money? tell me the name of the person with authority who's not here today. They're good ways to check people out. Find out their history of what they do. Has this been reported to a committee? Often in serious cases of commercial litigation or personal injury with insurance companies, they roundtable these things before you ever get to a mediation, and a committee of 3 or 4 are going to decide this is the limit, and you'll get a bonus if you can settle it for some amount under that. I mean, you want to find out as much about the dynamics of how they're going to settle as you can. What about considering going as far as you can with the person without authority? Say, we know you have no authority, but why don't we continue this and come to a point where you can say, we recommend this number and take it back to your company, so we're not all wasting time. Lastly, if you really continued on, you might even want to run the risk of saying, why don't we try and close this gap, keep going as far as we can, and then even seek the mediator's proposal at last resort, take it back to your company, and if both sides agree on the mediator's number, we have a deal. If they don't, we have no deal. Neither side would ever know from the mediator what the other side did unless it was a deal. So these are some of the things, but remember, if it's a lack of authority, the further you get down the road, the more I think you want to go the second route of hanging in there. And if it's right at the beginning, I lean toward Ben's thought about just get out of there and start the mediation at another time, because you lose the human dynamics of what goes on that day in that room. Last thing that I have seen that can be successful is, well, I'm sorry you don't have the authority and it's 3 o'clock in the afternoon and I know your insurance company closes at 5. Let's see if we can't get a conference call with Jim on the line. And I would make it a video conference call if at all possible. It's not as good as being there in person. It's better than just being on a phone. And again, these are just things that I have seen that come up that can really, you just sit there and wonder, what can I do? Well, these are some of the things that I've seen good lawyers do over the years when it looks like you're in this tough place. Talk about tough. Let me give you another sticky issue that seems like it comes up more often than I'd like to see it. It's 7:30 at night. We started the mediation at 9 in the morning. It's been moving slow. And one side looks at me and says, let me tell you what, David, you tell them $1 million, not a penny less. Take it or leave it. And I want you to tell them just like that. Do you understand? Look, man, I understand. I write down all offers. I don't ever leave it to memory. If you ever see a mediator and he doesn't write down when you give him a number, tell him to write it down. Ask them to repeat it to you before they go to the other room. Well, what are you going to do now? Mediator comes in, he's got a job to do, and he says, the number is $1 million, take it or leave it. How do you respond? 7:30 at night, you've been there all day. You're the lawyer. I'm just in there looking at you, just like I am right here. What are you going to do?
It depends on your brand, what you think the case is worth.
The other side, they do not think the case is worth $1 million.
It depends on what I think.
No, when you say are you the mediator or are you the lawyer? You're the lawyer. Yeah, okay. Well, okay, let's say take it or leave it $1 million, and you're the other side, and it doesn't matter plaintiff or defendant right now. Let's just say you're the defendant and you don't want to pay more than $750. You're not going to pay more than $750. That's what you think the case was worth. How do you go back to them?
I think with that attitude, I think it stops.
Okay, everybody agree? Normally I have found when it gets late at night, this is crazy. I'm talking about when I say late at night, I remember one time Ray and I had a case, it was 1 in the morning. Joe Huff and I had one 2 a.m. or something. But the later you hang in there and stay, the better it is for both sides. There's something about you come in the morning and you're just ready to fight. I can't tell you why. I really can't. So I try and really make the parties unhappy with me, and we don't adjourn. I mean, until they're just on the floor, we just keep right on going. So anyway, I'll bring in hamburgers or whatever, but no, we normally just keep going. Some things to think about, because I know time gets short. If you get a take it or leave it offer, here's some things I've learned from other good lawyers along the way. Of course, one answer is you can just leave, just as the first response. That's always something you can do. Here it was $1 million, take it or leave it, and the defense is thinking, I'm not going to go more than $750,000. So if you're a good defense lawyer, one thing you can do is, would you, Mr. Mediator, go in there and I need some more information. Why are they so hung up on $1 million? Is there some magic to that, or is it just they're tired? I come up with 4 or 5 questions. Second thing you could do is change the scope of the negotiation by introducing some new deal points. I'd like to talk about terms of payment. Are they planning to pay me within 2 weeks? The check, do they want to get their check in 2 weeks, or could the insurance company, whatever we pay them, do it over quarterly? Because that might make a bearing. So I'm shifting from that demand to other questions to keep the negotiations open. And also, it could be some novel approaches that the other side hadn't thought of. A discussion of minor points. I'm the defendant, and you ask the mediator, would it make a difference if my client apologized? We've never talked about that before. And I know there's been harm here, else we wouldn't be offering money. What if we agreed to parts of the deal and negotiated on other parts? And one of the best approaches that I have used as a litigator many times, I don't know why I like it, when people come in and say, take it or leave it, $1 million, I go right back and say, $750,000. I don't say take it or leave it, but I just keep negotiating. Let them leave. I'm not leaving. So ignore it is something that is also something you might want to consider. Now, I want you to, I don't know if you need to write this down, but I have found, I use a lot of technology, like one PowerPoint you're going to see in just a minute. That's all I got. So when I put up this PowerPoint, I want you to really study it, because to me, it nails what mediation is all about. And Ben, if you can see it, you really good. Rosie can see. Oh, you got it there. Okay. All right. I'm going to read this cartoon to you, because you can't see it. That's too bad. I got to read this to you. I got it here somewhere. Can y'all see that? I can't. Well, it's too bad. Let me tell you the general gist of it. Blondie on that first frame is telling Dagwood sitting in the chair, I've got 5 things for you to do today, or 10 things. 10 things for you to do today. And he says, I doubt I can even do 5 of them. She says, how about if you just do the first one? And he says, it's a deal. And then in the last frame, he says, only a real pro could have escaped from a trap like that. And she's walking away thinking, all I ever wanted him to do was the first one anyway. All right. It just tells you a lot about human nature and how to just hang in there. And that's what I mean about winning is litigation, and this is reaching a resolution. If I go back to about 8 or 9 months ago, I had a horrific case in which I was representing a bank executive in North Carolina who was going to work, and it was about 10 to 8 in the morning, and he got off a little commuter train, and he's at an intersection, crosswalk there, the light turns green for him to go, and the little man that's white to show you can walk, and he's halfway in the crosswalk, and a truck makes a right turn into him. He's a very strong guy. He's about 6'2", big bicyclist, weightlifter, 42 years old. He wrestles to get off the bumper of the truck and wrestles, and after 7 seconds, he succumbs to the power of the truck as the gears shift. Driver clearly doesn't see him. He falls under the truck and his head is crushed and he's killed. We represent him as a plaintiff and sue the trucking company. A lot went on in the case, and first he walked into the path of the truck. I've heard that many times in my career. Fortunately, in this case, there were these security cameras that the police department put up. It had the whole thing on film. It showed everything that happened, so they were dead in the water. I mean, they knew that. And so we mediated this case, and it took us about 10 hours. And we get a settlement. My client's the widow, and they're a very religious family. And I'm packing up. I shake hands with the other side, thank the mediator for his work. And as I'm getting ready to go, my client, who has given me permission to talk about this, I'm still not going to tell you her name, but she said, David, is there any way I can go speak to the driver? I said, I think that'd be really good. Don't get upset. I mean, I don't know what I said, just don't get upset, but certainly if you want to see him, yes. And I cleared it with the lawyer on the other side. They met in the hall. They did not say a word. They just hugged each other and wept. And wept and wept. You jump forward now 5 weeks, and I worked out with the city's police department to retrieve his effects. He had a torn suit, he had his pocket keys and a wallet, and he also had a Bible in his vest pocket because he was going to work early. He was leading a men's Bible study group that night at the Baptist church. And he was going to prepare 30 minutes before he went to work at his office desk. And so we returned all that to our client. 48 hours later, I get a call from her. David, you don't know how much this means to me. That Bible is the most valuable possession I now own. I said, well, I'm glad we were able to retrieve it. And she said, I want to give it to the truck driver. Do I have to clear that with anybody? I said, I just want you to think about it. She said, I don't need to think about it. I prayed about it. I want to give it to him. She mailed it to the truck driver. And recently, she sent me this note. It says, David, as you know, I sent Ted a note, journal, and the Bible. I wanted to send you his very sweet response. It brought tears to my eyes and touched my heart. God is faithful. I hope all of you are doing well, and some complimentary remarks. This is what the truck driver said. Kathy, so good to hear from you. I was so very happy. God is so great. I can't start to tell you. This thing has been very hard for me. I know it has been for you as well as your daughter. I'll never be the same. If you ever want to talk to me, here's my number. I would ask that we keep praying. Thank you for thinking of me. I love this Bible. And it's signed. You can't get this in a trial. This is not a bankruptcy matter, but I think you can relate because there are also some very emotional issues when you're dealing with a bankrupt estate. And so I have found the power of mediation to really be so moving for me as a trial lawyer that some years ago I decided that's all I want to do is move from being a spear thrower to a peacemaker. And I hope you'll find opportunities along the way to use it in your profession. Any questions? Happy to take them. Thank you.
Thank you so much, David. I think that you have given us a lot to think about, and you've taught us never to mediate with Blondie.
That's true.
Thank you so much for being with us, and if you would accept this little,
Oh, thank you. Thank you very much.
you may open it now, if you wish to do so.
Sure, so, you know, guys don't know how to open gifts pretty. That's what I've seen.
And again, I want to thank everyone for being here in Augusta, to be with all of us here in our courtroom that we're all proud of who practice here. And with David, we're delighted to have you back in Augusta, David.
Glad to be home.
Anytime. And while he's opening that, let me just remind us of a couple of things that I saw in the Venture magazine that just came out. You might have seen the nice reference to the Drake meeting that we had that Jim put in there. Jim, we thank you for all your good work last time. So I take a look, I think it's
Oh, that's
page
very
8.
nice.
There we go. All right.
Beautiful, thank you.
And, look,
It says the Drake, Georgia Bankruptcy American Inn of Court with appreciation with my name and date. It'll be on my desk. I thank you.
thanks so much for being with us. Thank you all. We have a little reception out front, and please join us for that and speak to David out there. Thanks for being with us.